Yeah. Sorry for, yes. So as you could see, this meeting will be recorded. So, but yeah, it's really nice to welcome all you here. And the reason why I invited you today here was because our Constitutional Court last year celebrated 25th anniversary, and also last year we could celebrate 20th anniversary of Constitutional Complaint. That is, as you know, instrument how person can protect his or her violated rights at the Constitutional Court. And I just wanted to bring you all here and to speak very briefly about your country's experience, because you know that we are always using also at the court a comparative method, and comparative method is a very common method also for during studies, and therefore I think that for audience could be very interesting to make some comparison how this system works here in Latvia and how this system works outside of Latvia, in Estonia, in Lithuania, in Bulgaria, in Slovakia, and also in Poland. Because I can say for sure, when I had to do some research things, I'm always checking what's going on in your countries. So therefore, this is the reason I invited you to participate in this conference, where we'll discuss comparative aspects of
Anita, I do not hear you.
No, she disappeared. She has obviously problems with, yeah.
Yeah,
Welcome back.
Yeah, but what happened? So I was excluded. So excluded. So maybe I said something wrong. So I'm sorry for that. But it's nice to be back. So I hope that technical things will not destroy our meeting. But yeah, maybe let's agree that here we have also audience, and also if during your speeches and presentations somebody will have some questions, let's agree that all those questions and discussions we will organize after all presentations. So, and also you can use our chat room if you want to ask something. But as I said, all questions we will settle out after all presentations. So, okay. Let's start our conference, and first speaker will be my friend, my very good friend, if I may say so, Toma Birmantiene. She was a judge at the Constitutional Court. Right now, she is a professor at Romeris University, and she is very active in different events. And I know that Lithuania introduced constitutional complaint procedure just some years ago. Therefore, especially for us, it will be very interesting to find out how this system works in Lithuania. So, dear Toma, the floor is yours.
Thank you, dear Anita, for inviting and for this possibility to share the experience regarding the constitutional complaint and regarding Lithuanian experience. We are very, very modest, and we have very, very modest experience. As you are celebrating 20 years, we can celebrate only 2.5 years. So the constitutional complaint was direct application for the person to the Constitutional Court. It came on the stage only in 2019, when the Constitution was amended. So from the 1st of September 2019, people, individuals have a right to access Constitutional Court directly. Though constitutional control works in Lithuania for a very long time, and in that comparison, we are old and maybe have more experience even than Latvian Constitutional Court, because we started in 1993. But nevertheless, for a very long time, indirect access to the Constitutional Court was prevailing. And this indirect access of individual to the Constitutional Court was rather working well through the whole court system. As in Lithuania, any court of any level had the right to appeal to address to the Constitutional Court regarding any legal regulation that it has to apply in its case. So that's why a lot of individual problems were solved through this channel. But of course, in 2019, it was absolutely, how to say, we felt even a little bit uncomfortable that the whole Europe, maybe only 1 or 2 countries are left that they do not have direct individual complaint. So in this case, in 2019, this instrument was introduced. The introducing of this instrument didn't change the whole scope of the constitutional control in Lithuania, because it is still more or less abstract control, and the Constitutional Court has a right to decide on the constitutionality of legal acts. And it is laws and some governmental acts, presidential acts, of course, not a lower level acts, the acts of ministers and others, they are going through the administrative court channels. So introducing the constitutional control, there was only opened one additional channel of the access. But this additional channel, of course, is different from those channels who existed before. And it is a little bit more closer than the channel that uses the courts. Because if we look to the president institution, to the group of parliamentarians, to the parliament itself, they can address the Constitutional Court even without even just having doubts whether the legal regulation is in line with the Constitution. When we go to the courts and when we go now to the individuals, only in those cases when the courts, regarding the court's power, when the court has to apply that legal regulation, has a right to address to the Constitutional Court. The same situation looks like and for the individual. But for the individual, of course, there are some additional complications because, first of all, exhausting of legal remedies. You have to exhaust those legal remedies. In the Constitution, it is written like this, but in practice, it means that you have to have the last decision of the court. And when you address the court, we have introduced only very limited individual complaint, not a full individual complaint, but rather limited, because you can address only regarding the legal act and which was the basis for your decision at the court. So in this case, you can't ask the Constitutional Court to look whether the court was correct in the application or whether there were some other problems, only if you think that the legal regulation that was the basis for the court to adopt the decision, and then this decision has to be regarding yourself, so individual can't address the Constitutional Court regarding the application of any law by the ordinary courts regarding relatives, friends, or so over. So in that case, it is very, very, how to say, very narrow in comparison maybe with other individual complaints, institutes or models of individual complaints that we have in other European countries. Are the citizens or individuals, are they very active? The first year it was more than 200 applications. The second year it was a little bit less, but nevertheless, only a very modest part of those applications go through the barrier of the admissibility. And in first year, it was only 3%, in the second year, 6%, but nevertheless, we still have less than 10 cases that are decided in the Constitutional Court. The Constitution gives only some very small notions regarding this right. All things, all details are in the legislation. and that legislation is the law on the Constitutional Court. So even the timetable when you can address to the Constitutional Court, if you have that last decision of the ordinary court, it is 4 months. And this was established in the law, not in the Constitution. So there are some criteria. Some of that criteria is established in the legislation itself, but of course, some criteria now is developed by the Constitutional Court itself while deciding different cases. And for instance, this exhausting of legal remedies, though in the Constitution, it is written like very, how to say, a little bit more open than in practice, but theoretically, it became much more narrow. Because as in Lithuania, we have very wide possibilities for a person to address the court on any case. So that's why in reality, we have those applications that are how to say, in compliance with the last decision of the court. So not any other institution, not for instance, ombudsman maybe, let's imagine, or any other institution, but only the court decision. Regarding those 4 months, the Constitutional Court is very strict, and there are very, very, very small possibilities only to prove that you have missed that term. So in this case, the Constitutional Court is rather very, how to say, very strict on these relations. So if to look to the practice of the Constitutional Court, what were the problems and how the Constitutional Court looked to the cases, in those cases that the court didn't accept those applications. For instance, of course, first of all, this is rather, in this case, the person has addressed only in those cases when we speak about laws and governmental acts and presidential decrees. All other legal acts of lower level, they are not, you can't address regarding them to the Constitutional Court, they go to administrative court. The same is regarding the actions. You can't you can't address the Constitutional Court regarding the actions of the institutions, only legal acts. So the abstract control is is the main form and the main possibility. Only in some cases, individuals try to say that some constitutional norms are in contradiction between themselves. So the Constitutional Court said that no, they do not decide these questions. Again, there were some applications that Lithuanian legislation is in line with European Union law, and the Constitutional Court didn't accept that application also. And sometimes the individuals are just complaining that some factual situation is very uncomfortable. It is not in line with the Constitution as they do think, and the Constitutional Court rejects this application. There were some applications that people were asking the Constitutional Court, they wanted to renew the proceedings in the court. Of course, the Constitutional Court said that it's not, and in some cases it was also regarding the problems not of yourself, but on regarding the other people. So so the legislation that you can address the Constitutional Court, of course, is rather narrow in the scope. But regarding whether it is enforced or whether it is not enforced, for instance, it's not now, how to say, not now enforced. The individual, of course, can address, because in some cases it is the same like with the court applications, of course, because in some legislation that is not enforced now, but could make some problems for the individual. Like in any other case, if the Constitutional Court says that any legal provision is not in compliance with Constitution, of course, it's understandable that it's applicable for everybody, but the problem could be, and we still do not have, if that application was applied before. So how it will work for the past and not only for the future. So I think that in future we could have some applications of individuals that maybe they were not, that legal regulation was just used regarding them before, but of course 4 months, and there are rather strict rules. So maybe in future there will be some other possibilities or some other channels, maybe from the ordinary courts, just to solve this problem. What is the result of your application? If you apply as an individual physical or juridical person, you have a decision of the court. So the proceedings in the ordinary court could be reopened. And if it is, if the legislation is not in line with the Constitution, but the Constitutional Court has no right to give any compensations. So any other mechanisms, they are not used. Whether individuals, how they use this right. Still now we have some problems with abuse of this right, because some individuals sometimes are just almost every morning they're writing to, addressing the Constitutional Court. So in some cases, the Constitutional Court had to adopt some decisions regarding that they would not look to those applications of the person. So some measures are also taken in this line. Are the applications that were decided by the Constitutional Court important for the society? The problems that individuals are raising out, are they important? Yes, and one of the cases I would like to address your attention, it was very interesting, when a person who violated the administrative legislation and he had to pay a fine, he addressed the court and he proved that he was right. So it was not his fault that some fine was he had to pay some fine. And he raised a very interesting question regarding to the Constitutional Court, that it happens so that this fine, if he would pay that fine, it will be much less money than what he paid for the lawyer, for the private lawyer to help them in this case. And in this case, it is very interesting because Constitutional Court said that it's of course not in line, that if a person addresses, if he was a governmental institution, so it's administrative institutions are fining somebody, and if a person in a court proves that he is right, so then these legal expenses that he had faced have to be covered partly. No, the court has to decide how much it has to be covered by for the individual. So I think that though we have very modest experience, there are several cases, but some cases are very picturesque, very interesting, and very important. So thank you for attention.
Thank you, Toma. Thank you very much for this interesting, let's say, introduction to your constitutional complaint procedure. I already made some questions, but I will raise them later on. So, and thank you once more. And the next speaker is my colleague from Estonia. Right now, he is working at the Luxembourg Court, European Court of Justice, but he is together with us, and thank you for that. But you know, when I was a PhD student, I read one article in international journal, Juridica International. And I read his article, and then I thought it could be very much interesting to meet this author. And you know, my dream came true, and I met him some years ago in Riga. And it's very nice to see you again here in our international conference, dear Madis. But I have to say some words about Estonian experience, that, you know, Estonia chose completely different model. Estonia doesn't have any constitutional court. Supreme Court solves constitutional law issues. So therefore, it will be very much interesting for everybody to find out how this individual mechanism works in Estonia. So, Madis, the floor is yours.
Thank you, Anita. Thank you very much for these kind words, and thank you for the invitation. I'm really glad to meet you again and to meet all the other speakers here at this little conference. Just a little clarification. I'm working in Luxembourg, but I'm not a judge there or something like that. I'm working at the Directorate for Documentation and Analysis. But yes, I'm in Luxembourg right now. The crucial question, you have asked me this before, and I'm trying to answer this in my little presentation. Do we have individual constitutional complaint in Estonia? I think I can a very clear answer, and the answer is yes and no. To start with, it is indeed still disputable in Estonian constitutional law theory whether the constitution establishes a right to individual constitutional complaint to the Supreme Court, or if all courts have a direct constitutional obligation to enforce constitutional rights and to perform constitutional review. In 2017, it was the last time the controversy about the individual constitutional complaint sparked again. The context was this time a plan of the Minister of Justice to introduce the individual constitutional complaint to the Constitutional Review Court Procedure Act. This plan triggered exceptionally harsh critique from several authors. The plan was particularly criticized by Ülle Madise, the Chancellor of Justice, Ivo Pilving, President of the Administrative Law Chamber of the Supreme Court, as well as by Märt Rask, former Chief Justice of the Supreme Court, in the press. The main arguments were that there is no gap in the judicial protection, that the introduction of individual complaints would lead to an unnecessary increase in the workload of the Supreme Court, that it would create the risk of politicization of the Supreme Court, and that it would undermine the competencies of the Chancellor of Justice. The majority of the Supreme Court did not support the draft law as proposed by the minister either. The Supreme Court was in majority, therefore, critical too. This standpoint to criticize the individual constitutional complaint is theoretically based on the understanding of Estonian constitutional review system as a diffuse system. However, the opinion of the majority of the Supreme Court was dissented by the Chief Justice of the Supreme Court at that time, Priit Pikamäe, and by Supreme Court Justices Henn Jõks, Erik Ergandberg, Ants Kull, Villu Kõve, and Peeter Roosma, who found that the problem introducing an individual complaint to the Constitutional Review Procedure Act is appropriate, and that regardless of the specific solution, this issue must be dealt with through legislation. Erik Ergandberg expressed cautious support for the institute of the individual complaint in the literature too. In the press, Rait Maruste, former Chief Justice of the Supreme Court and Justice of the European Court of Human Rights, and slightly more cautiously, Uno Lõhmus, former Chief Justice, Justice of the European Court of Human Rights and European Court of Justice, expressed clear support for the idea of introducing individual complaints in the Constitutional Review Court Procedure Act. The theoretical basis of this view in favor of the individual constitutional complaint is based on the view of Estonian constitutional review system as a concentrated system. The strong negative reaction of such a vast part of scholars was somewhat surprising and, in my opinion, regrettable. as we are going to see, the individual complaint already exists in the Estonian system of constitutional review on the basis of the consistent case law of the Supreme Court. Despite this, no excessive increase in the Supreme Court's workload or politicization has so far been observed. However, if the individual constitutional complaint were removed from the legal order, there would appear an unconstitutional gap in the right to access to courts. Since the principal function of the Chancellor of Justice is to help to guarantee constitutional rights, it would only be consistent if she or he were the first proponent of the individual complaint. Thus, despite of the endorsing voices, the Minister of Justice withdrew his plan, and the individual constitutional complaint continues its shadowy existence based on the case law of the Supreme Court. Well, or does it? Let's take a closer look. The individual complaint has been recognized in the Supreme Court's case law in 2003. Then the Supreme Court heard an appeal brought by SB, that is Sergei Brusilov. This is interesting. He's a convict, and his name was in the Estonian version for a long time public. It was not deleted. The judgment was not anonymized. Now the Estonian version is anonymized. There are the letters SB. However, the English version, and I checked it yesterday, is not anonymized. So I can still speak of Sergei Brusilov, who had been sentenced to 6 years imprisonment under the criminal code for theft. The criminal code, which the new penal code, which entered into force on 1st September 2002, laid down a maximum term of imprisonment of 5 years for Brusilov's sentence for incriminated acts. After having completed 5 years imprisonment, Brusilov brought an appeal before the Supreme Court for the correction of judicial errors and requested that he be exempted from continuing to serve his sentence. The Supreme Court and Bank upheld the appeal and declared the Implementation Act of the Penal Code unconstitutional, insofar as it did not provide for any reduction of the sentence of imprisonment imposed pursuant to the Criminal Code, up to the maximum limit of the deprivation of liberty laid down in the corresponding paragraph of the Penal Code. The main argument for the admissibility of these proceedings was the requirement under the paragraph 15 of the Estonian Constitution that the protection of constitutional rights must be free from loopholes. The Supreme Court has stressed several times after that the aim of the constitutional right enshrined in the first sentence of paragraph 15 of the Constitution is to ensure effectively access to courts without any gaps through appropriate court procedure. The gap arises in particular when there is no procedural possibility to enforce a substantive claim. It follows from the above that the Supreme Court has basically recognized the existence of the individual complaint. The aforementioned, however, only concerns the norm control complaint. But has the Supreme Court recognized the existence of the judicial constitutional complaint, that is, the constitutional complaint against the decision of the court of the last instance, which is the most effective constitutional procedural remedy too? In the period subsequent to the Brusilov judgment, the Supreme Court initially appeared to be willing to recognize this judicial constitutional complaint. However, in the following period, the Supreme Court expressly ruled out the judicial constitutional complaint in the case of Murat Kilic. A Turkish sea captain for long-distance ferries was married to an Estonian national and held a long-term residence permit for Estonia. He applied for Estonian citizenship. This was refused on the grounds that the applicant had not stayed in Estonia for at least 183 days per year in the last 5 years. The administrative courts dismissed the appeals and did not initiate constitutional review proceedings, despite repeated explicit requests of Murat Kilic. The applicant lodged an individual complaint against the judgment of the Administrative Law Chamber of the Supreme Court before the Supreme Court, which was dismissed by the Constitutional Review Chamber. The latter stated succinctly, pursuant to the Constitutional Review Court procedure, the Constitutional Review Chamber is not the higher court than the other chambers of the Supreme Court to which appeals can be lodged against decisions of civil, criminal, or administrative chamber. This precedent has been followed by a number of unsuccessful attempts to directly or indirectly challenge the Supreme Court's decision before the Supreme Court with a constitutional reasoning. As a consequence, according to the unequivocal case law of the Supreme Court, there is de lege lata no judicial constitutional complaint in Estonia. Such a solution may not sufficiently guarantee the constitutional rights, a right to a loophole-free access to justice. So I'm coming to the conclusion. To conclude, the individual constitutional complaint as a constitutional review procedure indeed exists in Estonian constitutional review system. However, the existence is similar to the existence of a ghost. Some of us know someone who claims to have seen it. The Supreme Court has so far held only one individual complaint to be admissible. Given the many questions raised in relation to the individual complaint, it is advisable to lay down the conditions for its admissibility de lege ferenda in the Constitutional Review Court Procedure Act. But the main question, what does all this have to do with Shakespeare? The Hamlet monologue continues. Whether 'tis nobler in the mind to suffer the slings and arrows of outrageous fortune, or to take arms against the sea of troubles and by opposing end them. This seems to be one of the crucial everlasting questions addressed to every modern society, including Estonia. Are we ready to take arms against the sea of troubles and by opposing end them? Or should we continue to suffer in the mind and dismiss the infringements of the state power simply as the slings and arrows of outrageous fortune? Thank you very much.
Thank you. Thank you, Matis, for your brilliant presentation. And as we could see, lawyers are very creative people. So we can use in our scientific works and even international conferences, so poetry. So thank you very much. The next speaker should be Lali Papiashvili, but unfortunately it seems that she is not enjoying us today. Hopefully, I hope that maybe she will enjoy us later, but this is the reason why I should give a floor to the next speaker, Lucia Mokra. She is also my very good friend. I met with her in one international event. She is a dean of the faculty at the Bratislava University, and she is a very active person in different fields. And as we can see from our program, today she will speak about relations between European Court of Human Rights and Constitutional Court from Slovak perspective. So, Lucia, the floor is yours.
Thank you very much, Anita, for the floor and also for inviting me for this conference. I believe that even in the next months or years, we can get this kind of talks even in person, which will be really great. But let me start with my presentation. And I even actually prepared the presentation, you know, like, so I'll try to share my screen. Not so much, let's say, familiar whether it will work when I will just share it and continue. So I will use this kind of a opportunity to have it. I believe it will be fine. So I will be talking today about non-admissibility or admissibility of constitutional complaint in Slovak Republic. And I will underline some kind of approach which is visible from the case law, from the jurisdiction of the Constitutional Court. So, actually what I'll try to tell you in this sense is that I will be talking about whether the constitutional complaint, as we have it in the Constitution of the Slovak Republic, and we have it from the beginning, so from 1993, with some kind of an update or amendment in 2001, is really a tool for the fundamental rights protection, because as you will see, many times the approach is rather fluctuating, and it is at the end sometimes more a tool of a different with a different goal than to protect the human rights as we initially had the intention to have it. And of course, one of the answer, I'll try to just elaborate, definitely not answer because that's not my role, how the Constitutional Court may contribute to the effective protection of the human rights. Because as you can see, then the European Court for Human Rights is the one which review many times the Constitutional Court judgments in relation to human rights protection and try to give the direction to our Constitutional Court how to proceed in relation to individual complaints. And this is actually the message where it's not always properly heard by the Constitutional Court. So that's why the number of cases from Slovakia is still increasing in Strasbourg. So as I had mentioned, the constitutional complaint had been presented in the Constitution in 1993. So it was still the Article 127. There had been some slight change in 2001 with the biggest amendment of the Constitution related to our membership to European Union. Currently, it is stated in the 4 paragraphs, from which the very first one is the substantial, the other 3 are more procedural. So in this sense, I rather focus on this first one and try to explain what are these kind of obstacles or the limits of the constitutional complaint in the Slovak Republic. As it is stated in this first paragraph, the Constitutional Court shall decide on complaints of natural persons or legal persons if they are pleading the infringement of their fundamental rights or freedoms, or human rights and fundamental freedoms resulting from the international treaty, which had been ratified by the Slovak Republic, and which actually is not decided by another court. And here it is pretty important to just get it to the details of this provision. So it means to look when the Constitutional Court may decide, and actually how it take this competence in its own hands. What it is important to say from the beginning is that the Constitutional Court, when deciding on the constitutional complaint, is always making it within the principle or within the boundaries of the principle of subsidiarity. So it means that it tries somehow balance between its position in the national system. So as it had been mentioned by my predecessors in this conference, can decide about the constitutional complaint only where there are already exhausted all the national remedies. So it means that the general courts are deciding firstly about any complaint related to the violation of human rights and fundamental freedoms, and then only comes the Constitutional Court. But another balance is in relation to the international human rights treaties, because the Slovak Republic is bound by both by the UN human rights treaties, but also by the European Convention on Human Rights and Fundamental Freedoms. So in this sense, the Constitutional Court is trying to make its own place as a top in the national system, but still to be conform with the international obligations as such. So it means when it is deciding about the human rights, it is clearly stated within its own practice that if there is another court dealing with the case, there is no competence of the Constitutional Court to proceed in the application. This was pretty much the issue which had been connected with the previous wording or the original wording of the Article 127 of the Constitution, because there had not been clearly stated the role of the Constitutional Court, which is not actually the part of the general scheme of the courts with the general jurisdiction, but it's the Constitutional Court which is stated as the individual court. And there had been a number of cases between 1993 and 2002 where the individuals had submitted their applications both to the general courts and to the Constitutional Court. So to prevent the different decision-making, and of course to prevent improper implementation of the principle of res judicata, the Constitutional Court always ruled when there had been the lively proceeding before the General Court, that it is not the competence of the Constitutional Court to rule about the case. And then finally, the mentioned Amendment 90 from 2001 make it clear that the Constitutional Court deal as a last instance court when the actual all national remedies in protection of human rights had been exhausted in proceeding before the general courts. Of course, one issue which is connected with the decision-making of the court is that the Constitutional Court tried to make its own position rather as a very rigid and formal, in a way that when the case comes to the Constitutional Court, the court can decide only about the review rather than to decide about the facts, and that the application has been precisely clear. So in this way, the court ruled that it is not a court of effect, but rather it's the court which has only the review competence. And that's why the court is ruling only about the very precisely stated violation of the human rights. Fortunately for the individual human beings, this had been accompanied with the obligation to be represented in proceeding before the Constitutional Court by the registered attorney. So there should be prevented dismissals of the constitutional complaints because they are not legally perfect and factually clear. But on the other side, it also led to the situation that the Constitutional Court many times tried to withdraw the complaints and try to make it in a way that the complaint is not factually clear, or the violation had happened before 2002, where the amendment of the Constitution had been adopted and became efficient. The European Court for Human Rights reviewed this position of the Constitutional Court and said that the court had to decide about the applications rather based on the principle of human rights protection than on this principle of the legal certainty. So it means that even some of the cases which had been started before 2002 had been reviewed by the Strasbourg Court. But the decision-making practice of the Strasbourg Court was not always clear. And I just tried to give you the insight of two different cases, where in one the court said that not all the remedies had been exhausted, but the application is considered as admissible. Meanwhile, just 1.5 years later, it states that not all national remedies had been exhausted, but the application is not admissible. So even the European Court for Human Rights was not very clear related to the constitutional complaint position in the Slovak Republic, which was not so much helpful for the Constitutional Court itself. And that's why they tried to build their own a doctrine of adoption of or admissibility of the complaint submitted to the Constitutional Court. What actually had been another point connected with the admissibility or not admissibility of the constitutional complaint was the petit of the Constitutional Court. The Constitutional Court itself identified and interpreted the Article 127 of the Constitution in a way that it is just the tool for individual protection of fundamental rights of freedoms. So it means that the active or actively legitimized persons are only those which declare that their human rights had been violated. So it means that it excluded any kind of third party's complaint or intervention, especially in relation to criminal proceedings where the number of cases had been submitted by the family members instead of the people who had been imprisoned or detained. Then the Constitutional Court also in number of complaints ruled that there is impossibility to rule about the complaint if the person had died or is deceased, or there is also very limited access to the legal persons to use the constitutional complaint as well. And a special ruling had been adopted in relation to the position of public authorities. I will mention in a few minutes. What the court actually deal with this had been that when constitutional complaint had been submitted rather by any other subject, they tried to identify their role by the petition very strictly, and the court never tried to somehow extend their competence to deal beyond the petition and to even review the constitutionality of the law which should be applied. So it actually means that the court only follow what had been written in the petition. And in comparison to understand the rigidity of the constitutional competence in the Slovak case, I usually use the Czech example where they have the same text of the competence of the Constitutional Court, but their Constitutional Court, when finding the petition of the complaint as needed to be explained in more complex understanding, they try to do so because they understand that in the center of the constitutional complaint, there is always the human being whose rights had been violated. This is not the case of the Slovak Constitutional Court, which always follow and strictly follow only by the petition. So it means that if even there is any doubt, or any potential circumstances which may extend the petition, the court overruled it and followed the petition instead. And this also led to the number of situations where the court decide in accordance with the valid and efficient law, also that law had been later on submitted to the court and asked for the constitutionality review, whether the law is conform to the constitution. So the principle of the human rights protection and the legal certainty had been definitely not considered in this approach of the Constitutional Court. This is something where we can again find out that Strasbourg Court give us some guideline, because it states that this is not a strict or rigid competence of the Constitutional Court, because the court may use the doctrine jura novit curia, or the court is the master of law, and it is actually the competence of the Constitutional Court to really focus on the complexity of the issue itself, as stressed in the number of cases I just mentioned, those against Germany, where it is explicitly stated, and which can be used actually as the guideline for the Slovak Constitutional Court as well. And as I mentioned, the Constitutional Court here in Slovakia is rather very rigid in this sense, not so much flexible in understanding that they have the competence as the master of law to interpret the constitution and to protect the human rights. So it means that it really limits the application to a very limited group of people. Yeah, so it means only natural persons with a very clear petition, who are represented by the attorney and who actually have the full legal capacity, and they are only alive. So it means if the person deceased throughout the proceeding, they actually lost the possibility to protect their rights or freedoms. There is no explicit provision which allow the persons, or like the inherent persons, to continue the case. But as I mentioned, it is not explicitly stated, but you can again use the principle jura novit curia, and the court, I would believe, can follow the proceeding, but they actually didn't do it at all. But on the other side, some positive approach had been adopted there, that even persons with limited legal capacity can submit the claim, and the court has to firstly deal with their active legitimacy and then with the process. So they are not excluded as such, although the previous negative other interpretation had been mentioned. Specific position is guided for the public authorities, but this is very comparable to any other constitutional complaints in the other European countries, that the public authorities may have the access to the Constitutional Court throughout the constitutional complaint, but only in cases where they have the equality position to the other parties or in the disputes. So, for example, in private law, like in the administrative law, in the proceeding about the building and buildings and so on. So there, the public authority is not exercising the public power, but is the equal part in the proceeding, and that's why this authorizes it to be the subject of the constitutional complaint. So when I get to another and almost last point to get or to be on time, as I mentioned, the biggest problem is the way how the Constitutional Court examines the constitutional complaints, and it examines it only in a way of a very strict approach by the petition and by the active legitimacy of the individual who submitted the complaint. But it didn't examine the constitutionality of laws. They actually themselves interpret their position and their competence coming from the Constitution in the ruling from 2004, that the Constitutional Court cannot examine the constitutionality of laws which should be applied to the concrete individual complaint. And they argued by the division of the competencies that the constitutional complaint is decided by the chamber, by the Senate, and the constitutionality review is decided by the plenum. But this is rather by the full court. So they argue that they cannot forward it from the chamber to the plenum, to the full court, because that's actually like two different competencies. But when you look on the mentioned Czech example, this is rather a procedural obstacle, because you can every time forward it from the chamber to the full court to decide both about the constitutionality of the law which should be applied, and then about the concrete case of the individual complaint itself. So it is rather procedural, not the matter of fact obstacle. But this also led to the situation, and the last case I would like to mention because of the limit of the time, that's the one connected to the individual complaint of 5 companies, private companies, who had submitted the application to the Constitutional Court due to the restrictions adopted in the pandemic. So they had been closed for almost 1.5 years, and that they go and exhausted all the remedies on the national level from the first instance up to the Supreme Court and then to Constitutional Court. And the Constitutional Court, when decided this case, dismissed the application based on the fact that they cannot or they didn't have the competence to assess the constitutionality of the matters. And according to those matters which had been adopted, the authority dealt fully in the competence which had been stated in the measure. So they didn't deal with the constitutionality of the measure, but rather dismissed the application itself. But this is the different approach which had been adopted by the European Court for Human Rights, which almost immediately, when the complaint had been submitted to the Strasbourg, decided about the admissibility of all 5 complaints, and starts to investigate and deal with the whole process of the observations and decision making. This application is actually still pending because of the exchange of the observations of the government and the legal representative. But what we can say is that this will be a decision which will again underline the necessity to connect the constitutional review and the individual constitutional complaint decision, because, and I can follow here, a few months after the Constitutional Court dismissed the complaint, the individual constitutional complaint, they decided about the admissibility of the general prosecutor application about the review of the constitutionality of the competence of the public health authority to issue the measures restricting the work and the life in the Slovakia. So it means that in one way, the court decided that they don't have a competence in this case to decide about the constitutionality of the matters and dismissed the individual complaint. And then a few months later, they decided about admissibility of this constitutional review. So it actually gets us to the situation where it looks on the first side that the court is not doing the same or not using the same measure for the constitutional review and for the constitutional complaint. So to conclude it, our experience and our using of the constitutional complaint is rather restrictive. The Constitutional Court make it as a own internal limitation of the meaning and scope of the constitutional complaint, very narrowing the understanding of the constitutional complaint as a tool, which I can say led to a limited access to the justice, because we have it quite very limited in a way to get to the Constitutional Court itself. So, and this can be also confirmed by the different understanding in Strasbourg and our Constitutional Court. So to conclude, based on the examples I mentioned also in the presentation, there is rather no constitutional review, but administrative review in relation to constitutional complaints. The court is not acting as a master of law and strictly follow the approach. What it is stated is considered as the valid and efficient, and we will follow only the petition, not considered the human rights and human being in the center of their interest. So that's why a number of applications are then submitted to the Strasbourg court, which looks like as a guarantee of the access to the justice in the last instance, because the national court is not following this approach of having the human being in the center of the human rights protection throughout the constitutional complaint. So thank you very much for your attention.
Thank you, Monica. Thank you. Thank you for sharing Slovak experience, and thanks for interesting examples, and also many thanks for your time, because I know that deans always are very busy. So thank you once more. And right now I have to give a floor to another one, my best friend, Monica Kvator. Monica is representing, I think, the best university in Poland, Krakow University. And we've been cooperating together with Monica for several years. And Monica is very successful in different projects. Right now, she's leading research group at the Krakow University, where different researchers, including me and Martin and Lucia, are involved. And I know that she also worked some years for Constitutional Tribunal. And yeah, Monica, the floor is yours.
Thank you very much, Anita, and thank you very much for the invitation. It's my great pleasure to be here only online, but it's even great. So I've got also the presentation. I will try to upload this. I hope that I will manage. I don't know whether you can see it.
Yeah, we can see. We can see. All is working.
So I will try open like this one. Maybe it will be better even. Yeah, so I'm going to talk about this issue that may seem to be very technical concerning a legal person as an initiator of the proceeding before the Constitutional Court, but this issue is also connected with more general and maybe even more important problem that is the subject, I mean, the issue of the subject of constitutional rights and freedoms, and the question which appears in the presentation by Lucia, whether legal persons are entitled to apply to the Constitutional Court and whether they are the beneficiaries of constitutional rights and freedoms. So firstly, I will start with some general remarks concerning the Polish Constitutional Tribunal, as I think it's quite important to emphasize that it is one of the oldest constitutional courts in Central and in Eastern Europe. It was formally established 40 years ago during the communist time, before the political transformation in Poland, which took place in 1989. The legal basis for its operation was created in 1982 when the amendment to the communist constitution was adopted, and the first judgment was issued by the tribunal in May 1982. And under the current constitution that was adopted in 1997, the tribunal is a part of a judicial power.
Monica, just to tell you that we don't see your presentation switching. So
you see all this.
We see only the first slide. So I suppose you continue talking on the slides, but we see only the first slide.
And this one? Now?
Only the first one. Only the first.
Okay, so maybe I will try to upload again. Okay.
Mm-hmm.
Maybe like this one. And
maybe if you click on the full screen down,
yes.
where it will
and
be
now
better.
do you see the first one, or just
only the first one?
Still the first one.
Maybe if you click on the on the full screen button, which
and here.
Yeah,
yes, now we can see it. Yeah.
It works.
So this one is with 10, and now is the other one. Yes, can you see?
Yeah.
Yes.
Great.
Sorry. Okay. Yeah.
Sorry for this those problems. Okay, so as I mentioned, nowadays the Constitutional Tribunal is a part of the judicial power, which is mentioned by this Article 10 concerning the principle of the separation of power. Its judgments are final, which is not so obvious in case of Polish Constitutional Tribunal, because they were not final before 1997, and they are also of universally binding application. And the 40-year judicial activity of the Constitutional Tribunal can be divided into 5 periods. The first covers 1986 and 87, when the tribunal operated on the basis of this communist constitution of 1952. Then the second period concerns the years 1990, 1997, when the tribunal mainly adjudicated upon the principle of a democratic state ruled by law. This principle was introduced to the communist constitution in December 1989. And it was a principle on the basis of which the Constitutional Tribunal was trying to democratize the legal order in this period before the adoption of the. And then the next period, which followed by the entry into force of the current constitution in 1997, can be characterized as the concretization by the Constitutional Tribunal of the new constitutional rules and principles, strengthening of its position within the state system. The next period was marked by the constitutional crisis of 2015 and 16, which, as you probably know very well, caused a serious conflict between the tribunal on the one hand and the new parliamentary majority and the government, formed by this majority, and also the President of the Republic that is connected with this majority. And finally, since 2017, as a result of far-reaching changes in the composition of the Constitutional Tribunal. In fact, we have a new Constitutional Tribunal with the new judges. The tribunal has started to be dependent on the governing political party. And now, going to the very topic of my presentation, I must emphasize that constitutional review is, of course, the main function of the Constitutional Tribunal, and the proceedings before this organ may be initiated or by the constitutional complaint or a question of law or an application. When it comes to the question of law, which is regulated by this Article 193, it can be submitted only by a court in the course of adjudicating a case. So therefore, it is not possible for a legal person to initiate proceedings in this way. However, such possibilities exist in case of a constitutional complaint and in case of an application. And in both cases, a legal person can be initiator of the proceedings before the Constitutional Tribunal, although of course under a different condition. So when it comes to the constitutional complaint, which is regulated by this Article 79, should be Section 1, not Section 10, sorry. A constitutional complaint may be filed by anyone whose constitutional rights and freedoms have been infringed. So a complainant may challenge the provision on the basis of which a court, a judgment of a court or a decision of the administrative organ has been issued in his or her case. A Polish constitutional complaint is therefore directed against a legal regulation, not against a decision issued on the basis of this legal regulation. It is a means of protection of constitutional rights and freedoms, which means that it may be brought to the Constitutional Tribunal only by the person who is the subject of those rights and freedoms. The Constitution doesn't directly grant legal persons the capacity to submit the constitutional complaint. As you can see in this article 29, the legal persons, but also the natural persons are not even mentioned. We have a very general category that everyone is entitled. And of course, the same concerns the regulations of particular rights and freedoms. Generally, legal persons are not mentioned as the beneficiary of constitutional rights and freedoms. But there are some exemptions to this rule that the Constitution doesn't regulate rights and freedoms belonging to the legal persons. And here we have three such kind of provisions as the exemptions. So Article 11 of the Constitution, which concerns the constitutional rights of the political parties. And political parties mostly, in most cases, are legal persons, not always, because it's not mandatory for the political parties to be registered in a special register. So that's why we have also some political parties smaller without legal personality, but most of them, of course, and they are legal persons. But anyway, in this Article 11, there is mentioned that they are entitled to some rights and freedoms. This freedom to be created, the freedom of functioning or operation, are the rights that that were granted to political parties. The same concerns Article 25, which introduces the principle of equal rights for churches and religious organizations, and also Article 59. Which grants trade unions the right to organize labor strikes and other forms of protest. As a rule, however, the provisions that establish rights and freedoms stipulate that these rights may be exercised by everyone or only by citizens. So rights that are only available or granted only to citizens, such as the right to vote, for example, are only available to natural persons. because of course only a natural person can have the status of a Polish citizen. But the situation is different with those rights and freedoms which are granted to everyone. Among this category, according to the case law of the Constitutional Tribunal, we can distinguish those rights and freedoms that by their nature are available only to natural persons, and an example is freedom of consciousness, for instance, and those that can also be exercised by legal persons. So freedom of economic activity, the right to the protection of the property is the examples of such kind of rights and freedoms. So those rights and freedoms that are mentioned as the rights and freedoms of the legal persons, and those that are mentioned that are the rights and freedoms for everyone, and by their nature that can be exercised by legal persons, they can be protected through this constitutional complaint. And the fundamental problem with legal entities is that their standing to submit the constitutional complaint in a given case depends on whether they are subjects of the rights and freedoms whose violation they challenge. As beneficiaries of constitutional rights and freedoms, they must be designated by constitutional. They must be designated by constitutional provisions as a beneficiary of those rights and freedoms. If the status of the beneficiary of a given right or freedom has been granted to them by statutory provisions, they have no right to lodge a constitutional complaint. And a good example for this case is Article 61, which concerns the right to receive obtaining public information. As you can see, according to the Constitution, it is the right that was granted to a Polish citizen only, but according to the statutory regulations, this right was granted also to to everyone, so it means also to the legal persons. But in case of legal persons, this kind of right is a statutory right, so it means that it cannot be protected by the constitutional complaint. So it's the difference that, for instance, associations can exercise this right exactly in the same way as the Polish citizen, but the association is not entitled to submit a constitutional complaint of this Article 61 of this right, because for the legal person, it is not a constitutional right. A legal person must not only prove that it was the beneficiary of the constitutional rights and freedoms whose violation it challenges, but it must also prove that it is the addressee of the decision or the ruling issued on the basis of the challenge provision. If the decision of ruling concerns, for example, particular member of the association, then only that member may lodge a constitutional complaint, and of course the association is not entitled. And in the jurisprudence of the Constitutional Court, there is a problem that is connected with the status of so-called legal persons of public law. It is the category that was created in fact by the Constitutional Court and described when it comes to the meaning in the case law of the Constitutional Court. So these are legal entities created by the state, or partially, or even from the beginning, or controlled by the state in some way. So they may be companies in which the state treasurer is a majority shareholder, but also they can be companies in which state treasurer is the minority shareholder, or the companies in which the state has influence on the staffing of key position. This is particularly true of energy or gas companies or other of the public-private nature companies, such as you can see on the presentation. In the jurisprudence of the Constitutional Tribunal, three different approaches to this type of legal entities have emerged. So the first one is that some of the adjudicating panels have held that legal persons of public law do not have any standing to lodge a complaint with the Constitutional Tribunal, as they are state entities and not private one. So it doesn't mean that they are partially state and partially private, because there is a state which is engaged in this kind of entities, and that's why they cannot be regarded as beneficiaries of constitutional complaint. That's why they cannot submit the constitutional complaint. Secondly, other jurisprudence panels have taken the position that these entities have standing to complain because they are not part of the state. They are separate entities. They are not a part of the state, and also the other argument is that individuals are involved in the creation and operation of such kind of entities because there is a private involvement. So that's why it means that they are beneficiaries of constitutional rights and freedoms, and that's why they should be entitled to submit the constitutional complaint. And finally, the third and probably prevailing position was one that made the standing to complain of these entities dependent on the degree of involvement of the state in the operation or structure. So in other words, if, for example, the state treasurer was a minority shareholder, these persons, according to the tribunal or maybe some panels of the tribunal, could submit a constitutional complaint to the tribunal, but if the state was a majority shareholder, they could not. So it's worth noting that even with respect to the same legal entity, the adjudicating panels of the Constitutional Tribunal have presented different position, and KGHM, as you can see, on the presentation, is a good example of such kind of entity, which in some cases was admitted with the constitutional complaint and the other not. And just for the beginning, for the end, legal entities may also initiate proceedings before the Constitutional Tribunal by filling an application referred to in Article 191 of the Constitution. The right to submit an application is generally vested in the organs of the state. So the organs of the state are not entitled to submit any constitutional complaint in any case. But they are entitled to submit this motion, this application to the Constitutional Tribunal applications, which is not connected with a particular judiciary proceedings. And as an example, this right to submit an application has also been granted to certain legal persons that are mentioned on the presentation. So such as the national organs of trade unions, as well as national authorities of employer organization, occupational organization, churches, religious organizations. The most complicated, because it's also a part of the public authority, is this category, constitutional organs of units of local self-government. But in this case, these entities have only the limited legitimacy, because they may submit to the Constitutional Tribunal an application in which they challenge a provision or a legal act that concerns matters within their scope of activity. So it is a large problem in many cases that they cannot challenge certain provisions because they are not concerned the scope of activity. So in conclusion, I would like to state that legal entities, of course, have the possibility to initiate proceedings before the Polish Constitutional Tribunal. Some of them are explicitly indicated as entitled to apply. So it is the case of Article 191 and the application to the Constitutional Court. In the case of a constitutional complaint, the legitimacy is a consequence of a broad interpretation of the word everyone, which is in Article 79 of the Constitution. So as a subject entitled to lodge a constitutional complaint, and a broad understanding the concept of a subject of constitutional rights and freedoms. And at the same time, it should be added that more legal persons are applying to the Constitutional Tribunal. So I think it's also quite interesting, but probably for the other presentation. So thank you very much for attention.
Thank you, Monica, for your brilliant presentation and sharing your experience. And also, I would like to thank you for answering on my questions in my several emails. When I have some questions, I always addressing Monica, asking to share her experience based on Constitutional Tribunal, of course. And actually, you mentioned a very topical issue at the moment in Latvia. We also have debate about whether legal persons of public law can have constitutional rights, and it means whether they could or can apply to the Constitutional Court. Later on, maybe we could debate about this, but thank you very much. And right now, the floor goes to my good friend, Martin Belov. He is a representative from Bulgaria. Martin is a full-time professor. He is lecturing in different universities, and he is so active in writing. He has published several books also in English, and his recent book is about constitutional semiotics. In this book, he speaks about constitutional algebra, geometry, etc. So different interesting things. But today, Martin will speak about Bulgaria's experience. So, Martin, please, the floor is yours.
Thank you very much, Anita, for this kind invitation. I feel very comfortable to be among friends, although remotely and by Zoom. I'm sorry there might be some noise around me, but there are some renovation works ongoing. The colleagues from Wrocław, from Krakow know exactly what they are. I just told them when we are there. Previously, Maris Ernest was talking about ghosts, and I'm wondering whether I shall talk about ghosts or a very carefully planned child, right? Because ghosts means that you have something which you don't know what it is, and it's in between worlds, right? So in Bulgaria, right now I have a very challenging task to talk about the so-called missing constitution, right? And Bulgaria constitutes rather an exception in European perspective, as being a country where never has been a constitutional complaint, right? Moreover, you may wonder if a country doesn't adopt constitutional complaint, actio popularis, or any other form of direct or semi-direct involvement of citizens, instruments for approaching the Constitutional Court to protect their rights, whether this is a very careful consideration of a perfect model, or that might be a tacit consensus for kind of postponing the introduction of that instrument. So in that regard, you know, there is this famous classification of constitutional courts into state courts and human rights courts. Of course, that's as all typologies, it also employs over-exaggerations. So no constitutional court is entirely state court, solving, you know, issues related to institutional design, and no constitutional court, even the most activist and most human rights engaged courts, as the German one, are entirely human rights courts. But if you anyway want to have some clarity where the Bulgarian Constitutional Court stands, it is definitely a state court, right? And this is due to one main reason, namely this is the lack of any form of direct access of citizens to the Constitutional Court. Moreover, the indirect access to Constitutional Court, as you will see in the next remaining 13 minutes or so, is also very limited, very oblique, very indirect, and very discouraging, right? So we have a very conservative system for access to constitutional justice, and you will see the arguments why, or the reasons, because these are not exactly arguments, the reasons why this is the situation here. So, having said that, I have to say that we have mostly, almost exclusively, very remote indirect access. And, you know, there are, in all countries, Bulgaria included, there are institutions that can generally approach the Constitutional Court with asking questions for the compliance of the different acts, mainly the acts of parliament, with the constitutional rights. And in the Bulgarian case, these are the 150 of the MPs, the government, the president, the Supreme Court of Cassation, Supreme Administrative Court, and State Prosecutor General. So you can see that many of these institutions do not have the political incentive to do this, especially that might be the case of the government. And usually that system of approaching the Constitutional Court has been used mainly by the opposition, right? Mainly these 1/5 MPs or the president when he's in coexistence with the governmental majority in parliament. Of course, the courts, especially the Supreme Administrative Court, to lesser extent the Court of Cassation and the State Prosecutor General, were using the opportunity to approach the Constitutional Court, asking whether certain acts of parliament or governmental, acts of parliament or the parliamentary standing orders, or in very few cases, the acts of the president are infringing constitutional rights. But sometimes this was also an escape strategy, namely it was shifting of the hot potato to the Constitutional Court in few occasions. This is a clear reason why actually the Bulgarian Constitutional Court has a rather scarce, rather limited case law on human rights. And it is produced mainly on the basis of two competences that the Constitutional Court possesses. First of all, the Bulgarian court possesses an atomic option, namely it can issue binding abstract interpretations of the Constitution, right, which is theoretically a gateway to judicial activism, right, and to the virtual amendment of the Constitution, right. In the 1995, there was, for example, a case when the Constitutional Court was asked what is rule of law in Bulgaria, and if you are a very active judge and you want to really you dream of being a constitutional legislator, you can really rewrite the Constitution if you are asked such a question, right? What is rule of law, right? So you can redesign the model. And the other competences on the basis of which human rights were tackled was actually the abstract and the concrete control for constitutionality of acts of parliament. So these are actually two competences. So these three competences constitute the main source of case law related to human rights. The Bulgarian constitutional legislator realized gradually, due to internal but mainly external reasons, mainly pressures from the Council of Europe, that there is a necessity for gradual opening of the access to Constitutional Court. And that's why two very incremental, very conservative amendments were introduced in the Constitution in that regard. In 2006, the Ombudsman was allowed to approach the Constitutional Court when he or she considers that acts of parliament infringe constitutional rights. So it was something a little bit similar to the Spanish recurso de amparo, right? Indirect constitutional complaint with many modalities as well. And in 2015, the same model was used for allowing the Supreme Bar Council, right? The Supreme Council of the Attorneys to do the same, to approach the Constitutional Court with demands for unconstitutionality of acts of parliament, right? So you can see that some time has already passed after these amendments, especially after 2006. And we can see that these were slight improvements, right? These produced a bit more active Constitutional Court, especially when approached by the Ombudsman, because the Supreme Bar Council kind of didn't take that wholeheartedly as a function of its own, right? So it was not very active there, but the Ombudsman used that opportunity, especially more active Ombudsman, especially in more media interesting cases, which can promote, of course, the Ombudsman standing as well. But this was a moderate success, right? So both in terms of quality and quantity. And also both these opportunities are quite limited. First of all, because the ombudsman can approach the Constitutional Court only when constitutional rights are supposed to be infringed. But so it's not a remedy against infringement of EU law, but also international treaties, right? And this is kind of unjust limitation, I would say. Second, such infringement could be raised only against if they are produced by acts of parliament, right? So the other acts are excluded from the scope of that protective mechanism, right? And finally, of course, when you have a filter like that, especially the Supreme Bar Council, it is really a long way to go until the Constitutional Court, right? So because the Supreme Bar Council needs to be approached by lawyers, by attorneys, and the attorneys, as we know also from the practice of our colleagues, are not so keen at really getting involved with constitutional law, right? It's not their, so to say, most comfortable, you know, this is not their zone of comfort. So another possibility for indirect access to Constitutional Court is via the ordinary courts. So through the concrete control for constitutionality, something which exists in many countries, more precisely in Estonia, of course, but also in France. This was a huge revolution when such form of control was introduced. It actually shifted the so-called French model into non-French one, right? So now other countries are sticking more to the previous French model than France itself. In Bulgaria, this is not the case. Why? Because we have additional filters, right? So if you are an ordinary judge, it doesn't matter whether you're a civil, criminal, administrative court judge, you are quite restrained. So, you know, on the one hand, the Constitution tells you that you can, well, the Constitution, as all constitutions, has a supremacy clause. And in theory, you may think that supremacy means real supremacy and also direct effect, right? Which means that the pure and genuine supremacy and direct effect should result in non-application of subconstitutional law if it contradicts the Constitution, right? This is not exactly the case in Bulgaria. So in Bulgaria, you have this first option. If you're a judge, you have this first option. If you have a pending case in front of you, you can just apply the Constitution. Is it true? No, right? Because there was a standing practice that actually we have a very concentrated control for constitutionality, and only the so-called pre-constitutional laws, right? The laws that have been adopted and enter into force before the entry of the Bulgarian Constitution in 1991, can be submitted to such more or less diffuse control for constitutionality. So actually this direct effect is in that regard limited. Second option, you can try to interpret the unconstitutional act in a constitutional manner, in something like a conformity interpretation. Of course, this is the highway to hell, to quote a very famous song, because this is the highway to inconclusive and incoherent practice, and it's again infringes rule of law, right? Because it infringes the predictability of the decision making of the courts. So the main option that a court has is to approach somebody. But in contrast to France and many other countries, where the courts can approach directly the Constitutional Court or the Supreme Court or whatever supreme jurisdiction there is for constitutionality, in Bulgaria there is a filter. So if you are a criminal or civil law judge, you have to approach the Supreme Court of Cassation. If you are administrative court judge, you have to approach the Supreme Administrative Court. And if you are a state prosecutor, you approach the state prosecutor general. And if they decide that the case is really worth approaching the court, the Constitutional Court, then they do this, right? So this is very discouraging. First of all, it's time consuming. You have pending case in front of you. You have to be courageous and you have to wait, right? To bother the big bosses up there. That's why this procedure is also rather dysfunctional, and there are very few cases when the courts dare to do this, right? So it's mostly the supreme instances that approach the Constitutional Court on their own liking, on their own initiative, and not so much because they have been approached by court of first or second instance. And I would say this is a very undue limitation because whereas you can theoretically speculate that maybe if you open the scope for access to the Constitutional Court for ordinary people, that might be extremely willing to approach the court, and this will flood the court, right? You cannot use the same logic for the judges, because if you don't trust your own judges that they have a reasonable, you know, judgment, which cases are really worth stopping and approaching the court, the Constitutional Court, then of course, then you have a huge problem of trust with regard to your own judiciary, right? So to sum up, because as you know me, I'm always fast, sometimes furious. So this time not so much. To sum up, we don't have any direct form of any direct access of citizens to the Constitutional Court. There is no direct constitutional complaint. There is no actio popularis. There are no other means. There are these very limited indirect options. Accessing the Constitutional Court through the Ombudsman, which is the most realistic one, through the Supreme Bar Council, which is less realistic, and through the courts, which is the least realistic, right? Because it's again up to two kind of judges to if this will succeed. First, the judge that tries the case, and second, the Supreme Courts. And that is why I would say we have this rather conservative outlook of the system for access to constitutional, for a system for protection of human rights in front of the Constitutional Court. And this is to an extent rather illogical, rather controversial, because it seems that the Bulgarian judges are in a better position to be safeguards of European law than the Bulgarian Constitution itself, right? Because the Bulgarian judges can approach, and in some cases they must approach, the European Court of Justice, right? And they do this relatively, for the Bulgarian mentality, relatively frequently, right? So they show some appetite in approaching the court, whereas they have no option, even if they wish to approach the Constitutional Court. And that's a paradoxical situation, because it seems that in Bulgaria, the EU law is better protected than the Bulgarian Constitution itself. So I hope I'm of course open to questions, and this was my very brief presentation. Thank you very much.
Thank you, Martin. Thank you for sharing your experience. And right now it seems it's time for questions. So you can raise your yellow virtual hand if you want to raise a question. So please do not hesitate. Yeah, Lucia.
Thank you very much. So I will start with a question, if I may. I have the question actually to Monica, because you had mentioned that there are the number of legal persons, and you even mentioned like political parties, churches, trade unions who may approach the Constitutional Court if they are beneficiaries of constitutional rights and freedoms. And I wonder what kind of rights, or whether there is actually some kind of cases where the court had decided about this, because I wonder that it is mainly about like a right to assembly, or I cannot imagine what can be the right of legal person in this sense, which the court had to deal with, because even when we are talking about political parties, it's rather like the individuals who are exercising the right. So whether there is some kind of, you know, like interpretation already, and so on. So from this point, thank you.
Should I answer now?
Yeah. Please go ahead. Yes.
Of course, there were many cases. For instance, in case of churches, most cases, I think they are connected with the property rights. And even we have a very interesting case which ended by the European Court of Human Rights, which was initiated by a church. It's a Greco-Catholic church. I don't remember exactly the whole name of this church, a Greco-Catholic church, which has got some properties to the east, I think, of Poland, and there was the expectation that the state will decide on the dispute which was between this church and the other church. I mean, there were some negotiations between those churches with the impact of with some state authorities, and finally the state the parliament adopted the statute that was without those expected regulation. And this was a very interesting case. I mean, generally the church lost this case before the Constitutional Tribunal. The tribunal said that there are no problem when it comes to the property rights, that the property rights of this church was not violated. But why this case was important? Because the representative, I mean the barrister which represented this church before the Constitutional Tribunal, realized that one of the judges should not take part in the adjudicating panel because he was a member of the parliament that adopted this statute before. And he applied to the Constitutional Tribunal for reopening the procedure, and the Constitutional Tribunal said that it's not possible because we have because the judgment is final. And this case, as I said, I mean, he lodged a complaint to the European Court of Human Rights, and there was it was I think like 15 years ago. But it was a very famous case because he was trying to prove that the Polish state violated the principle of the access to the court, because it's not possible to question the judgment of the Polish Constitutional Tribunal. There is only one instance and no possibility to reopen this proceeding. Yeah, and so it was the second possible right, and the constitutional complaint was also possible to construct the constitutional complaint around the right to a fair trial. So it is also quite often challenged by the legal property. But at the end, the parliament decided to adopt those legal provisions that were expected by this church, and that's why the church withdrew the complaint from the European Court of Human Rights, and that's why we have still in the provision in the Constitution this provision that the judgments of the Constitutional Court are final and it's not possible to question them. But anyway, yes. So those kind of rights. I mean, the right to a fair trial. I think it's probably the most often the pattern of complaint in such kind of cases, but also property rights, tax issues. I mean those obligations that are connected with tax law. Yeah. So I think that those can be also questioned, of course, by churches or religious organizations and so on. And in case of churches, it's also quite interesting that they have two possibilities of initiating the proceeding before the constitutional complaint, because they are mentioned in this Article 191. They can submit an application, but they can also submit a constitutional complaint. Because they can also be everyone. So this limitation that is connected with a constitutional right is connected only with constitutional complaint. So it means that even if they are not able to indicate the proper constitutional right that was violated, and even if they are not able to formulate or to construct the constitutional complaint in such a way, they can still submit an application, and they don't have to care about constitutional rights or freedoms. So they have in a better position than, for instance, political parties, because political parties can only submit a constitutional complaint, and it's very controversial whether they are entitled. We have some cases when the political parties were trying to initiate this procedure, and it was also quite controversial. As I understood correctly, in your case in Slovakia, not only such kind of political parties or other such kind of entities can submit constitutional complaints, but also public authorities, which is not acceptable in Poland, because in Poland, it doesn't matter whether the public authorities is in the same position as the individual. It doesn't matter whether it performs some public task, for instance. But what is important is that this entity must be the beneficiary of constitutional rights and freedoms. So the question is whether the public authority is a subject of this regulation concerning constitutional rights and freedoms. And the answer of the Polish Constitutional Tribunal is no. So that's why even the local organs cannot submit the question of law, which are very often in the quarrel with the central organs.
Thank you, Monica. May I continue? Just one brief question. It means the church can submit application in abstracto, also in a constitutional tribunal.
Yes, of course, because it is the main difference between a constitutional complaint and an application. In case of a constitutional complaint, we need a certain judicial proceeding, for instance, but in case of Article 191, it is a purely abstract review of law. So yes, it can initiate even such kind of proceeding.
Thank you. Thank you very much. Madis, you have a question.
Yes, thank you. I would like to ask all of you certainly something, but it was the biggest surprise for me, the Bulgarian model, and I would like to put these spiritual and religious symbols aside and just to address the point. Yeah, Martin, is Bulgaria a rule of law state?
That's a question. Thank you. Thank you very much for the question. That's a question that's related to the lack of direct access to the Constitutional Court, or that's a general question related to the situation in Bulgaria?
Of course, no. I mean, just let's us concentrate on this. I mean, on the basis of my presentation, I have some doubts whether Estonia is a rule of law state. So I'm asking you, is Bulgaria a rule of law state?
Well, that's a very complex question with a lot of much more complex answer than you can imagine. I can answer it in a more pessimistic way than I can think, namely that that question should, the concern should not necessarily be the lack of constitutional complaint. There are other elements of the rule of law which are much more fragile. But yes, that's actually a deficiency. You may wonder why. There is a lack of direct access, and the answer would be very Bulgarian one. It's not some very, there is no conspiracy. There is no desire to infringe rule of law. The main reason was very pragmatic. For the generations after the change, they didn't want to, and I'm almost quote the main argument in the discussion, to flood the Constitutional Court with complaints. Now, if you look at the average cases solved by the Bulgarian Constitutional Court, there were years, maybe like 10 years ago or 15, when there were like, and I'm not joking, like 10 to 12 cases in front of the Constitutional Court composed of 12 judges, which means that actually the workload was not that high. And even now, when there are more, they're still far away. They're lagging behind the, I'm here referring to Monica and something that she recently wrote, and I hope to publish in one of my edited volumes. Actually, even in the years when the Polish Constitutional Court has kind of a dropping in number of cases, they're much higher than the number of cases in Bulgaria. Does it actually really infringe the rule of law with view to access to court? Yes, to a certain extent. I'm not sure to what extent, because we don't have the empirical evidence how much the people will be interested. But in my view, and I don't think it's my view, it's general view in the theory, I would say this is a mainstream understanding, that the main function of the constitutional complaint is not that much the human rights protection of the concrete individual or company or juridical entity. It is much more the opportunity that this gives to the Constitutional Court to develop an extensive doctrine on human rights and to clarify these rights. And this is actually something which is not so much related only to rule of law, but also to sovereignist thinking, because, in countries, this sovereignist thinking is on the rise, but these guys are emphasizing the idea of supremacy of constitution. But in the Bulgarian case, with view to the human rights, it doesn't mean that much, because of course the Bulgarian constitution is supreme, for example, over the European Convention of Human Rights. But this is a very formal supremacy, because it's not, the Bulgarian constitution contains the very same rights that the European Convention contains, for the obvious reasons that it was adopted 1 year before the accession of Bulgaria to the Council of Europe. And then if you start looking at more concrete, dimensions and shapes of the human rights of the core, possible limitations, balancing of rights and stuff like that, you cannot find them either in the Constitution, which is natural, or in the case law of the Constitutional Court, exactly due to the lack of constitutional complaint. So by necessity, Bulgaria, and that's that. If you are a fan of the European Court of Human Rights in Strasbourg, in that regard, this even makes Bulgaria more rule of law country than others, because in fact, by necessity, you have to make recourse to the case law of the Strasbourg Court, because there is no case law of the Bulgarian Constitutional Court on many of the human rights. So this is a very complex answer, I know, to a very challenging and interesting question.
Yeah, thank you, Martin. Actually, I have a question to everybody. That is procedural question, let's say. And the question is, who decides on admissibility of the application? When application comes to the court, who decides to initiate the case or to refuse to initiate the case? And is this decision appealable or not? Because in Latvia, when constitutional complaint procedure was introduced, legislator completely changed the procedure. So right now we have a panel of 3 judges who decides to initiate the case or to pass a decision to refuse to initiate the case. And this decision is not appealable, it's final. How it is in your countries? So first, maybe Toma.
In our case, we do not have many vast experience, but those cases that I have looked through, they all are adopted by the full court. So the full court, when it rejects the case, when it adopts the decision, so you need to have a full court. Of course, in future, I hope so, if the workload will be very high and very big, maybe these cases will be different. But now, for instance, you can just trace and you can see the jurisprudence, and they adopt these decisions by the whole court in US.
Thank you, thank you. It means that your judges have to work very hard.
Of course, the judge looks inside, decides, and then there is of course, not all, I think about the rejection and misunderstanding between the president of the court and the judge, because in many cases, when any conflict is between the judge and the president of the court, the full court decides.
Yeah.
So there is a possibility.
Okay, thank you. Madis, how it is in Estonia, who decides to initiate a case or to refuse?
Thank you. I'm not certain in this sense how the technical procedure is constructed, because from my time at the Supreme Court, there are 20 years already, and it has changed, because at that time actually the president, the Chief Justice of the court, at that time, the assistant of the Chief Justice answered with a informal letter to the complaints. But since Brusilov case in 2003, the case law has changed, and these are all decisions of the court. And we have only one professional full-time constitutional judge. This is the Chief Justice. All others, all other members of the panel are ad hoc members. So I imagine that it goes through the Chief Justice, and the panel will decide that this is inadmissible, because there are quite many inadmissibility decisions actually in the case law of the Supreme Court. So finally, the panel, the chamber decides.
Thank you. Thank you. Lucia, how it is in Slovakia?
Yeah, actually, when the application is submitted to the Constitutional Court, it is then assigned to the chamber. And we have 4 chambers. And then the chamber firstly decide about admissibility or non-admissibility, and then proceed with the case. So it's the one which decides in the first moment. And then this decision on admissibility or non-admissibility is not appealable. So it's the final decision. And that's why number of applications, when they found non-admissible, they go to Strasbourg. So that's the issue. But it's actually the chamber of 3 judges, constitutional judges, who decide about admissibility or not. And if yes, they continue. If not, it's final, no appealable.
Thank you. Thank you. Monica.
Yeah, so in Poland, we do have the preliminary review in case of the application submitted by the private entities. So in case of those applications which are submitted by the public authorities, like the President of the Republic or the Prime Minister, there are no such kind of preliminary review. And also in case of constitutional complaint. So the procedure is in such a way that when this kind of applications submitted by the private entities and constitutional complaints are referred by the President of the Constitutional Tribunal to a single judge, to one judge of the Constitutional Tribunal, and he for the purpose of the preliminary consideration. And at this stage, it is possible that the judge, if it finds some defects in the constitutional complaint, it can request that the defects be eliminated within 7 days, as I remember correctly. And of course, if the decision is the negative of this one judge, it is possible to apply. And in this case, at the second stage, at the second instance, the case is analyzed by the panel of 3 judges. And they decide whether the case will be sent to the larger panel for the consideration, or maybe it will be the end of the proceeding. So I think that our is quite similar, as I understood correctly, to the model that was adopted in Latvia. For us, it is unique that there is there are two stages, because as I said, we do not have the possibility to appeal in case of Constitutional Court judgment. So in this case, yes, we do. Mm-hmm.
Thank you. Thank you. And Martin?
Yeah, for me, it's very easy to answer because of the lack of constitutional complaints. So it's the court in general, all the judges that decide to accept or reject the decision. So it's the same procedure for all other competences with regard to which the court is approached. And there is a ruling adopted by the court by virtue of which it accepts or rejects the application for a decision.
Yeah, thank you. So, other questions? Any comments? It means that it's time to finalize our session. I'd like to once more thank you for your time. Thank you for your contributions. And thank you for your friendship. That is the most important thing in my life, friendship. And I hope that next time we will see each other in person in Riga or in Tartu or in Vilnius or in Krakow or in Sofia or in Bratislava, whenever, but in person. And the last thing I'd like to say is let's pray for our friends in Ukraine and let's pray for the peace. Thank you. And see you next time. Bye.
Bye. Thank you.
Bye. Thanks a lot. Bye-bye.
Bye. Thank you.
Thanks a lot. Thanks.
Thank you. Goodbye.